Good afternoon, everyone. I now see that we are live on Facebook, and as we all know, that if it's on Facebook, it must be correct, right? Well, good afternoon, and thank you for taking your time and joining us today to discuss and learn about the Moore versus Harper case that the U.S. Supreme Court heard yesterday. I'm Natalie Tennant, former Secretary of State of West Virginia, and you can see we have some panelists around, and we're going to be talking about that. Well, this case that we heard yesterday in the Supreme Court, I call it the independent state legislature theory. In my opinion, I consider it the biggest threat to our elections process and our democracy. And that's why we're here. We're here to discuss this and see if those concerns are fair and warranted. And I also would like to say how proud I am of us here in West Virginia and these groups, the Greenbrier chapter of the NAACP, branch number 3227, and Race Matters West Virginia, and many of our national partners like DFAD, which stands for Declaration for American Democracy, Common Cause, and the Brennan Center for stepping forward with this virtual forum to educate ourselves on a complicated and complex case that could send our elections into chaos if the justices accept it. You know, because there are so many interesting and complex elements of this, we might as well go where it started. And it started in North Carolina. And Tyler Day is the Policy and Civic Engagement Manager for Common Cause North Carolina. And I'll let him explain, but the way I see it is that Common Cause and Rebecca Harper were just wanting fair maps in North Carolina. And when the North Carolina legislature didn't deliver, they sued. And so, Tyler, I'm going to let you kind of take it forward with that to kind of explain it a little bit. And then we have other panelists that can help back up that info too.
Thanks, Natalie. Just to provide some background, really all of this, I should say, Democrats and Republicans have both been gerrymandering North Carolina's maps for decades. But this stems all the way back to 2011 when we had racially gerrymandered maps here in North Carolina, and the court struck them down. And then the General Assembly had to redraw our congressional districts mid-decade, and they drew partisan gerrymandered maps. And it wasn't just analysts saying this and activists saying this, legislators themselves. And there's even a clip of former Representative David Lewis saying, "I propose we draw the maps to give Republicans a 10-3 advantage because I do not believe it's possible to draw a map with 11 Republicans and 2 Democrats." He actually said this. There's a clip on our YouTube channel, the Common Cause and See YouTube channel.
There's also the famous quote from the court. With surgical, they drew these maps with surgical precision to count people in and count people out.
Yes. So there's a long history of this in North Carolina, but this in 2016, like I said, it was very clear that they were drawing these maps for partisan advantage. So we took them to court again, and in 2019 there was Rucho v. Common Cause, and the Supreme Court heard this case regarding partisan gerrymandering. The question was, is this unconstitutional? And the U.S. Supreme Court said, this is terrible. This is really bad. It's bad for democracy. It causes all of these awful, problems. It creates a system in which voters are being disenfranchised. I'm paraphrasing them here. But essentially they said, hey, we can't do anything about it. We don't think that we have the power at being the U.S. Supreme Court to get involved with this. This is too political. And so they said, but you can go to your state courts. You can implement reforms at the state level. So fast forward to 2021, it's redistricting time yet again. 2020 census is over. And so we're turning to the General Assembly to draw our maps. And they did, and surprise, surprise, they drew partisan gerrymandered maps, despite criteria, I will tell you, where they claimed that and within the criteria, they said that they couldn't use partisan data. I have to tell you, looking at those maps, I have a hard time believing that that they didn't do that. If they did, it's pretty impressive because the maps that were originally drawn, many of you probably know North Carolina is a purple state. We have very competitive statewide elections, and that those maps would have likely resulted in a 10-4 split, 10 Republicans and 4 Democrats. But those maps, ultimately, we took them to state court this time because, again, the Supreme Court said, oh, you can go to state courts. And so the North Carolina Supreme Court struck those maps down. And in a huge historic ruling here, they claimed that partisan gerrymandering violated the North Carolina Constitution. It's the first time that they had ever declared this. So they nullified those maps and they ordered the General Assembly to draw new ones. They gave the General Assembly an opportunity to redraw the maps, and the General Assembly turned in a second round. And those maps, they said, no, you still haven't got it. you still drew these maps for partisan advantage. So they struck down those maps and they said, okay, we're bringing in special masters now because obviously you guys, we've given you another chance. You didn't do it. And so we're going to have special masters draw these maps. And so we had special masters draw the congressional maps that were used this time around. The maps that they drew were certainly not perfect, but they were a big improvement, and certainly in terms of the addressing the partisan advantage. The maps that the special masters drew ended up being a 7-7 split among Democrats and Republicans, which is much more representative of the state. I'll also tell you, I've looked at some of the data from Dave's Redistricting app analyzing these maps as a proportionality metric that is used. The original maps got an 11 out of 100 for proportionality. The maps drawn by the special masters got a 94 out of 100. And that proportionality metric is essentially measuring how skewed are the maps toward one party or another. So these were much better maps. We were happy. And we thought, okay, we can breathe. But no, the state legislature said, we're not done. They didn't want to give up. And so they appealed that case to the U.S. Supreme Court. And this is the case that we have now. And in that case, they claim that the state court had no authority to rule against them. And that is really the basis of this Moore v. Harper case. They are invoking the independent state legislative theory, and they are claiming that when it comes to federal elections, that the state legislature is supreme, and that state courts don't have the ability to come in and check them, as they did here in this case. And so that is really the crux of it, and that's what's about why we're so worried, because the whole reason why we had better maps this time around was because the state court acted as a check, and if they can't do that, then they don't have any muscle to back up their rulings. And again, this goes beyond just redistricting.
Right. And that's why, North Carolina is where it started. It goes beyond redistricting right now, because and I'm not the lawyers here. I got a law professor and I've got an election law expert too here, but it just simply it says we don't want to have to listen to the Supreme Court or the Constitution of our state. And that's where I'll bring in my colleague, because when there are cases like this, in election laws like this, it gains obviously national attention because it's more than just an impact on North Carolina and Common Cause. And so we saw this focus, and Ethan Herenstein is one of the election law attorneys at the Brennan Center for Justice. And he's been involved with this case for years. Well, maybe not years, a year. It's probably been a year. And so I'll say to Ethan, you've been involved. Where were you yesterday? And I'm going to let you take it a little bit about what this all means beyond North Carolina. So go ahead.
Sure. Thanks, Natalie. And hey, everyone, I'm Ethan. Yesterday, I was at the U.S. Supreme Court watching the argument in Moore versus Harper. That might be why I have big bags under my eyes, because I got to the court at 2 a.m. And just barely got in. It was a crazy day. So just starting off where Tyler left off. So this independent state legislature theory is being invoked in this case in Moore versus Harper to greenlight partisan gerrymandering in the state of North Carolina. If it's embraced by the U.S. Supreme Court, the results would, as we've talked about, go far beyond partisan gerrymandering. Well, first of all, go far beyond North Carolina, because it would stop any state court anywhere in the country from striking down a congressional map on the basis that it's a partisan gerrymander. State courts in all sorts of states, in New York and in Maryland, in Florida, and in Ohio, have all struck down maps that were unfair and were drawn for partisan advantage. And depending on how the court rules in Moore versus Harper, all of those court rulings could, be blown to smithereens, and the legislatures could be reinvited back to the drawing board and encouraged to draw maps as unfair as they'd like, and there would be no state court or federal court, because of the Rucho opinion that you just heard about, available to stop them. Put aside partisan gerrymandering, though, the implications of the theory, and I don't know, Natalie, whether we want to talk about where this theory comes from and why it even exists.
Yeah, you might want to get to that, because I talk more about it as the ISLT. And that was going to be one of my questions to one of you all. Like, why are we even talking about? Where did this come from, and why are they using it now?
Sure. So I'll do a very quick one, and then maybe other panelists, or we can get back into it later. But basically, taking one step back, the U.S. Constitution has a number of provisions that make rules for federal elections. One of them is called the Elections Clause, and that clause governs congressional elections, so elections for Senate and for the House of Representatives. And it says that the times, places, and manner of setting those, of holding those federal elections shall be prescribed in each state by the legislature thereof. So the long-running historical understanding of this provision that's governed, since the founding, has been that state legislatures get to, make the rules, but subject to all of the ordinary checks and balances that are the hallmark of democratic legislation. So if the state constitution permits a governor to veto laws, then the governor can veto election laws. If the state constitution permits state courts to, ensure that state laws are drawn in compliance with their state constitution, then the same is true of elections. The proponents of the independent state legislature theory take a different and I think highly implausible reading. And they say that because the Constitution uses the word legislature, it means that it's the legislature and only the legislature that gets to make the rules for federal elections. So state courts, nothing to do with it. Governors, arguably, nothing to do with it. Independent redistricting commissions like in Arizona or California that draw fair congressional maps, they get kicked out as well. It's the legislature and only the legislature. And so you could see why this has implications far beyond partisan gerrymandering. Some research that we've done at the Brennan Center has found more than 170 state constitutional provisions that govern federal elections. These provisions are sometimes crucial voting rights protections. 49 of the 50 state constitutions expressly protect your right to vote, which, believe it or not, is not expressly protected in the federal Constitution. Dozens guarantee free or fair or open or equal elections. Many more guarantee your right to vote by absentee ballot or by mail-in vote. And others just set crucial details and deadlines, like the when you have to apply to get registered to vote, or how voter registration actually happens. Under the independent state legislature theory, all of those constitutional provisions can get blown to smithereens. And the last thing I'll say is that because this independent state legislature theory only applies to federal elections, it relates back to this elections clause, which deals with federal elections, those provisions would still govern for state elections. So what that means is that the independent state legislature theory can create a sort of bizarre two-track election system where federal elections are held under one set of rules and one set of protections, And state elections, elections for your governors or your state representatives, are governed under a totally different set of rules, which would be, as Natalie can tell you more than most, completely chaotic.
Yeah, I mean, that's what I wanted to explain. And the many folks who are on here, I appreciate your being here. I knew, I think Delegate Walker was on here. She may have had to pop off, but that's, you talk about your county clerks and your local election officials who've had this extra burden of from 2020 when they're after the threats and all of the pushback against what they do. Can you imagine having to run 2 elections? And can you imagine all of you voting rights activists who are on this call and the media also on this call trying to explain that you can vote here and you can vote by mail for this election, but you can't for this election. So that's what we mean when we say there could be chaos taking place. And I'm going to go now. Thanks, Ethan. I'm going to go now to Billy Coyer, who is the state courts manager of the People's Parity Project in North Carolina. And I know that there are some questions on here and about what else can Boogie Butt. I think that you named yourself that just so you would hear me say that. Anyway, Boogie has a question about helping other voter rights groups against voter suppression. Now, this will help kind of give a sense of what else takes place around not just ISLT, but what other groups are doing. Because Billy, you also focus some of your work on checks and balances that ISLT would take away, but also reforming the legal profession that it's more fair to people. So when folks are on this webinar asking, well, what can we do, in addition to voting rights, you might be able to help them out with that. But, what does this case do for you and your work? Does it hinder or does it help you?
Well, I guess, Natalie, I would say, PPP is a national organization and we work with folks all around the country on issues around the courts and the legal profession. And I've been doing this kind of work for a long time. And in North Carolina, I've been involved with folks who were fighting gerrymandering, and they really saw the connection between the need to protect their state courts and have good state court judges and the gerrymandering and voting rights issues, because there had been all these huge legal battles over the years here. And while all those legal battles were happening, our state legislature was also trying to basically take over our court system to try to prevent them from undoing the gerrymandering. And so a lot of my work was trying to tell people about that threat to the courts and also tell them, your state courts are so important because of your right to vote under the state constitution, right? Ethan was just talking about how every state or 49 states have a right to vote under their state constitution. And what this ISLT theory does is really take away the state court's role in protecting the right to vote, at least with respect to federal elections and congressional districts. So in that way, it's going to be challenging, I think, because, I often tell folks that if you really want to get involved, if you're worried about what's happening in the courts, your local state court system, it's a lot, you're more able to affect change there. A lot of times you get to vote for who your judges are. And so a lot of times I tell folks, you need to get to educate yourself about this and educate other folks because these courts are so important to protecting your rights. But this case is going to make that a little different and a little more challenging. But I will say one silver lining is I think that, if the court rules that state courts can't do anything about gerrymandering, one thing that I think we'll see is that it'll kind of turn down the temperature in terms of the attacks on the courts that we've seen in North Carolina and other states. Maybe a little because you're going to have less litigation over election districts in state court, especially with respect to congressional districts.
I have a question, and we're going to go to Professor Atiba Ellis next. This may be the question. But if state courts, and maybe I'm getting too deep, if state courts aren't going to be allowed, if the justices accept this, and state courts aren't going to be allowed to hear the cases, and then the case I think Tyler referenced was that 2016 that the Supreme Court said, no, we're not looking at it either, then where do we go for, I mean, where's the checks and balances?
So,
Professor, I mean, I was going to introduce you
I didn't realize
properly, but I wanted to talk about a few things. But if you want to take that question, this is Atiba Ellis, and we're welcoming him back to West Virginia because he was a law professor at West Virginia University, then Marquette, and then heading now to Case Western University. So I have a couple, but go ahead and answer that, Professor, if we know right now the answer.
Well, in a way, the answer is don't know. I think and I mean, part of the difficulty here I was at a conference last month with a bunch of election law scholars trying to parse out for ourselves how all of this would look. And if the court adopted some version of the theory, and part of the trickiness here is there are a bunch of versions of the theory, right? There's one version that I think says the legislature reigns supreme, end of story, right? And maybe there is Supreme Court of the United States review, but as earlier panelists pointed out, all of those checks and balances and protections that could be brought through state court, or maybe the federal district courts, or maybe not, would get abandoned. So maybe you could bring a case in federal court. Maybe you could bring some kind of limited case. Maybe this gets narrowly read because that clause from the elections clause in the Constitution, Article 1, Section 4, talks about times, places, and manners. Maybe there's some other issue that's out there, but a lot of what we think about in terms of the mechanisms of voting, from how to get to your voting booth or whether you can vote absentee to the shape of the districts, are considered time, place, and manner structures, right? So it's hard to tell how this would shake out. And part of the question in front of the court is not only whether to adopt the theory, but how robust or muscular the theory would be. So that's one.
Yeah, and I guess that's
my take today.
Yeah, today, that's right. And another question I wanted to kind of pose to you too, and these are things that I've learned from Ethan and our colleagues, Liza Swearenbecker and Thomas Wolf, that so many amicus briefs have been filed also. And Professor, what I want you to do is first, we hear these things all the time, but first maybe explain to folks what an amicus brief is and why you thought it was important to send one in to write one in.
Right. So when it comes to litigation, and especially litigation in front of the Supreme Court on these major issues of what our Constitution means, the parties in interest, and here Ms. Harper and the state of North Carolina were suing each other. They're the parties, but there are rules that say, the rules of the Supreme Court that say people who have an interest in the litigation, who would be heavily impacted by it, can submit a brief on their own. And to be, to get into the weeds of it, a brief is basically a memo to the court. You can write an essay to the court to say what your position is. And so anyone who can demonstrate an interest, including a law professor, or the variety of briefs in the cases included the Association of Chief Justices of the state Supreme Courts across the United States, several think tanks, other professors, including colleagues who are good friends of mine, on both sides of the issue, all submitted briefs. And we all did that because we think this reshaping of how elections will run in the United States is so important that the court needed our point of view to help them make a decision. So that's why we submitted, that's why so many people submitted briefs. I, along with the Center for Anti-Racism Research at Boston University, and you'll probably have heard of the director of that center, Dr. Ibram X. Kendi, the writer of Stamped from the Beginning, which won the National Book Award. So famous anti-racism scholar. So his center and I collaborated on our brief. And we did so because we thought that an important perspective in the debate around partisan gerrymandering is one around how this runs the risk of replicating the kind of racial gerrymandering that is so much a part of American history. And we are afraid of that history of repeating again, racial voter suppression. And here's what I mean by that. And in those cases that we were referring to earlier, where the North Carolina General Assembly passed rules which had been struck down, our brief laid out the history of how a lot of those cases either were directly about racial disenfranchisement or had those implications, especially when it comes to even partisan gerrymandering. So the ones that were straightforward, and that quote about, targeting African Americans with almost surgical precision was from a case in 2016 called North Carolina NAACP versus McCrory. And in that case, the legislature, after Shelby County v. Holder came down and put into abeyance Section 5 of the Voting Rights Act, the primary way elections are protected in America against racial discrimination, the General Assembly went back and said, well, let's rewrite the rules. And in the process of rewriting the rules about how to register and when you can register and whatnot, they did a study, among other things, they did a study about African-American voting practices and then changed all the rules in response to all the practices they saw Black people doing. And so that's where that court came from. The Fourth Circuit said, you're targeting African Americans. And this wasn't just about registration, this was about districting as well. And then even with partisan gerrymandering, given the rates at which African Americans in North Carolina tend to vote for Democrats, it's hard to see the difference between the one and the other. So when we're talking about partisan gerrymandering, we're also leaving open that is unreviewable under the independent state legislature theory, we're leaving open the door to racial gerrymandering as well. And given that it could well expand to all these sorts of practices, our worry was that we would revert back to a time in this country over a century ago when, before the Voting Rights Act, Black people in Alabama asked the Supreme Court to intervene, and the Supreme Court basically said, well, this is just a matter for the state legislature. And if the state legislature doesn't want to protect you against these laws that you claim are discriminatory, not for us to talk about. If you think about it, the independent state legislature theory leaves open to repeat that same kind of problem from a century ago in a case called Giles v. Harris in 1912. And so this is true because
I'm sorry, I was just going to say, you put some of this in the brief then.
We did.
Because, I know that there have been many amicus briefs that have been filed. And I encourage our audience to go and read some of those. It would be a lot of reading. And just to follow up, the justices did not read them before the hearing yesterday. Is that correct? Either Ethan or Professor or anyone else? Like at what part of this consideration will they read all of those briefs?
Professor, do you want to take it or?
No, go ahead.
So more likely than not, the justices are not going to read every single page of every single one of the close to 70 amicus briefs that were filed. What will likely happen is one of their 4 law clerks will go through them and, summarize them in very short order, maybe a paragraph for each of the briefs. And then they might flag, the law clerk will, the most significant of the briefs, or the briefs that the clerk feels will be most informative for the justice. And then the justice might read a selection of them. any justice who sort of is in their right mind would have read the brief that Professor Ellis filed, which was wonderful. But more likely than not, they'll have a sense of the flavor of each of the briefs, and they'll know, for example, that dozens of conservatives and formerly elected Republicans came out against the independency legislature theory, for example, which was a great theme of the many amicus briefs.
Yeah, I mean, that's what I was thinking too. And you all, I've heard it said is that with every chief justice of every state Supreme Court came out against it, and that is rarely done.
I don't think it's ever been done.
Oh, really?
And I in the conference, I was in dialogue with my colleagues, and I don't think the Association of the Chief Justices of all the Supreme Courts has ever filed a brief before the U.S. Supreme Court, but they did here. So not only is it a bipartisan agreement, but it is an unheard of move for judges to file a brief before Supreme Court judges saying this will be disastrous.
Yeah,
Wow.
I was really surprised. Even our Chief Justice in North Carolina, Paul Newby, who's a very conservative Republican, I kept waiting for him to come out and say, I don't support this brief, but he didn't do that. He's a very conservative Republican, and he dissented in the gerrymandering cases when the court struck down the districts and said the court shouldn't do this. But apparently even he is presumably on board with what this group of folks that he's a part of is doing in this case, because I mean, he's also an expert on the state constitution and rights under the state constitution. And presumably he doesn't want to lose some of his authority as a state Supreme Court judge.
Wow, that's interesting. And it makes me wonder, does this also, I mean, it doesn't make a Supreme Court null and void, but does it make a Supreme Court null and void when it comes to election laws and things like that? I can remember being Secretary of State and having cases go to the Supreme Court, but they were about, putting someone on the ballot or taking someone off a ballot. I'm not sure where even that might be in place. That would be interesting. And thank you all for sharing the link. Sally Roberts shared the link of the professor's brief. And then there is a whole list of all the almost 70 amicus briefs that the Brennan Center has compiled that are all there together. Now, as we move forward a little bit, this is a really great discussion, and I want to pull in the Reverend Derek Biondi, who is with the West Virginia Faith Table, and talking about one of those briefs. And it's interesting that we would always see Reverend Biondi. I mean, whether you're talking about healthcare, voting rights, redistricting, the faith community is there, and it's tell us why. I mean, you're maybe on a national level filed the amicus brief, but this is so important to the faith community, right?
So one of the reasons why this is so important to the faith community, at least in my tradition, is that we believe that the law comes from God, and that God respects each and every person, that each and every person has this divine light of God in them. And so everybody matters. And our democracy is based on this system that every voice matters. And so anytime something gives some voices more say than others, it goes against what we believe as people of faith. And so this is incredibly problematic. Gerrymandering gives a stronger voice to some voters than others. And like it's been said before, it allows politicians to pick their voters rather than the other way around. And so as a person of faith, if God made us all and cares so very much for each and every one of us, each voice matters immensely. And so this is why it is very much an issue for people of faith.
Sorry about that. I see where you're coming from. And let me I'd like to start with maybe some questions from the audience. And I know there are a few reporters on also. I'd like to take those first, just in case you have a deadline somewhere else or you have to jump off. But as you can see, and being a former television reporter in West Virginia, I can see like this is a complex issue. I guess a headline, if anybody were given, we've already talked about the chaos that could ensue. I say, you take away the checks and balances. We all learned that in elementary school history, is how important checks and balances are and how fair it seems. And it doesn't seem fair if this approach would remove that. So first off, any questions from any media who might be on here? I haven't seen it pop up yet. I haven't seen any pop up yet. Help me. I want to go. Oh yeah, this was a good. Annette asked this question, and I'm just panelists. I think you could see it. Aren't the conservative justice ignoring Supreme Court precedent by apparently embracing the ISLT? Apparently, Annette knows more of the cases than I do, but I have a feeling Ethan and the professor know Smiley and Russo, and they were referencing Smiling and Russo, weren't they? Maybe Smiley. She says, I would think anyone trying to determine the intent of the founders would not conclude that they wanted such an absence of checks and balances. Who'd like to take that one? I know Ethan has a very interesting piece in Political from a couple months ago, but maybe if you want to talk a little bit about the history of, or answer that question, and then I have another question about what was taking place yesterday. Go ahead, Ethan.
Sure. So Annette, you're right on both points. The Supreme Court has rejected the independent state legislature theory in various contexts in cases dating back more than 100 years ago. So Smiley was a case from the 1930s where a governor vetoed a law that a map that a state legislature had drawn that the governor thought was bad. It was gerrymandered, and so the governor vetoed it. And the legislature, like here in Moore versus Harper, was unrepentant, and instead of accepting the ruling, went up to the U.S. Supreme Court and said, "Wait, the governor doesn't have any authority to veto our maps. We are the legislature. We have supreme power." And the U.S. Supreme Court said, absolutely not. I believe that it was unanimous opinion and said, of course not. The state constitution created you. The state constitution gives the power to the governor to veto your laws. That's exactly what happened here. That's checks and balances. That's fourth grade civics. You lose. Sorry, I think someone's at my door, but in any event, and then Rucho is a case from 2018, I believe, or maybe 2019, where the court, as was mentioned earlier, said federal courts can't get involved in partisan gerrymandering, but they said state courts can, and said that state constitutions can prevent gerrymanders. And so if the court were to turn its back just a few years later, that would be quite disturbing. And I don't know whether, Professor, you wanted to talk about maybe the second question about the history of the founders and the checks? Or
I think that, first of all, I think that both of those points are correct, especially the Ruccio point. The surprise, it would be surprising for the court to turn its back on Ruccio, at least implicitly, by saying, well, state courts can't get involved in that too. I think in terms of the founders and the checks and balances, I think that at least one perspective on this, because lots of people have written lots of perspectives about what constitutional design means, but I think the very basics, the sort of notion that no one branch of government gets supreme power over the way things work. And this is sort of the compromise position that the founders took, given the comparison of plans between, well, a strong president or a strong legislature in terms of Congress. Now, and so we think about these as checks and balances in the sense of no one actor can do one thing without it being at least subject to review by another branch of government. And scholars like to call this at least the core part of the Republican form of government, right? The idea that we elect the people who go and make the decisions, but there's always a check on them. And this is the model not just for Congress, the president, and the Supreme Court, but the model for each state, that there is always a review. If the legislature passes a law to regulate elections, the governor then gets to veto it or sign it into law, and then the courts get to review it to make sure it's in line with state law and the state constitution. So put in that sense, you can see how the extremist versions of the independent state legislature theory would just undo that entire structure, right? If the legislature can't be reviewed by the state Supreme Court, and in terms of federal law, Congress has backed off, or the court has backed off on regulating what states can do, then there is no check. But this was the constitutional design. I mean, Madison said, and I can't remember what part of the Federalist this is from, but the point is, this is the sort of core of how to make sure that government does not become tyrannical.
Yeah, he always gets the credit for saying he doesn't trust the legislatures. And I would also say, as a former reporter, as I told you, our fourth estate is also being chipped away. When you're talking about checks and balances, much of the time our free press is the opportunity to be able to do that. And Martha Minow has a great book out called Saving the News, where she talks about, because we don't have the local news, the cost of government is going up because we don't have the reporters that have the time and capacity to be able to question it. Anyone else have a follow-up on that? I know, Billy, this is kind of up your alley, or Tyler, or Pastor, if you wanted to follow up on something like that.
Yeah, well, I think when Professor Ellis was talking, I was thinking about some of the questions from Justice Ketanji Brown Jackson yesterday. She really kept coming back to this idea that state legislatures have no authority without state constitutions, right? They are set up by state constitutions. The constitutions lay out how they're elected, what kind of powers they have, and everything else. And to somehow say that this legislature can now act without worrying about what the state constitution says, it just doesn't make any sense. She kept coming back to that again and again because, you know, they don't really have an answer for that. You don't have state legislatures without state constitutions. So how can you let them get away with violating the Constitution? And the way it's always worked is courts decide when you violate the Constitution. They decide what the law is. That's the way it's always worked. And this case could totally upend that if the courts rule for our legislature.
Yeah, your legislature. Sorry about that, Billy. You're sitting in nice, beautiful outside in North Carolina, tempting us all. I thought that was very interesting too, and I'm glad that you brought that up, because I was going to ask Ethan, like, what was he thinking? Like, do you squirm when you're in there watching the Supreme Court, because you have to get up really early, and are you sitting there squirming not like I was doing when I was yelling at the at the TV yesterday?
You're just trying to pay as much attention as possible and read the tea leaves as best you can to try and get a sense of where you think this extraordinarily conservative court will end up. But hopefully this is a theory that's too extreme even for this extremely conservative court.
Yeah, we'll hope that. Karen had a question here too. Aren't the more litigants making a specious and circular argument when they claim the ultimate check on the state legislature's Congress, when then the congressional seats are the ones being gerrymandered and being formed by what the legislature says? I think we all kind of agree with that one a little bit. Ava, thank you. She asked, can an executive order from the executive branch at least temporarily assist with the prevention of independent state legislature theory? That's a thought. Like, at what moment would a governor do an executive order if that were possible? That's interesting, Ava. Anybody have a thought on that?
I'm happy, but Billy, feel free to weigh in as well. I don't want to.
Well, I was just going to say, I mean, that came up a little bit yesterday, and I think some of the broader versions of the ISLT could, lead to a smaller role for the governor, the executive branch, or like a local elections board or state elections board. But I think after the argument yesterday, I'm not as worried that they're going to accept that broader argument. But, who knows?
does it feel like, I guess some of the things, I haven't read everything, like the response, or not responses, but reaction from the court. I mean, can't they, it feels to me like, and this is from a lawyer, not a non-lawyer, so I won't get in trouble, but it feels like they're just almost too chicken to say, no, we're not doing any of this at all. We're not accepting any of this. So they're trying to find a little piece here, a little piece there. So we can, one, preserve our democracy, and two, give a little bit to these petitioners. I mean, no sense of that. All right, no one's going to take a bite on it. That's okay. You don't have to, because I come up with some strange questions. Betty wants to know, can we go back to the basics about effect on my individual vote? It would seem to me this is canceled out regarding electors to the president. And that's where maybe some of this thought came up again, because wasn't this a question of if you had independent state legislature theory in practice, could lawmakers then pick their own electors for president? Explain that, Ethan.
Well, so that's a really good and a really important question. And I want to be totally clear that the answer is no. To be sure, there are people who are misguided, like John Eastman, and that's maybe a generous word, who have invoked things that sound like the independent state legislature theory as part of an effort to overturn the 2020 election. But to be completely clear, the independent state legislature theory, although it's terrible and misguided for the reasons we've already discussed, is not a licensed coup. And the reason why is because even under the independent state legislature theory, federal law and the federal constitution would still constrain state legislatures. And any attempt by a state legislature to ignore the votes in a presidential election and to send in a slate of electors for the presidency that's inconsistent with the vote of the citizens of the state would almost certainly violate the federal constitution. And more importantly, any attempt to do so after the day that Congress assigns to be election day would violate federal law, where Congress has set the deadline for voting. And so there are lots of really horrible consequences that might come from the independent state legislature theory, but it is not a license to coup.
Now, could I jump in on that just briefly? Because I think underscoring, first of all, I think Ethan's absolutely correct. It is not a license to coup, and any sense of rule of law would endorse that view, which is why you may have heard in the news about the Electoral Count Act being strengthened, or efforts to strengthen that. Those sorts of things really matter. It's usually the minutia of election mechanisms, but we can now see how that would have a big impact. Without that, you would have these arguments taking hold. And I think it's important to note, like John Eastman, certain representatives of the Republican campaign during the 2020 presidential election, and all of these things were evoked. And certainly in the sort of so-called shadow docket litigation around the 2020 election, several justices in footnotes in some of their decisions were leaning towards favoring the independent state legislature theory specifically. So, it's not for nothing that we're having this conversation, given how it could upend certain parts of what is our democratic infrastructure. But certainly there's no getting around, to put it even most directly, there's no getting around the supremacy clause of the Constitution and how federal law would ultimately control these issues. The concern that we had in our brief, and many others had, was by not having state court checks, then this narrow line of authority, if that's the version that the court adopts, if it adopts it, would so upend all the other pieces of stability of elections and the supervision of elections that there can be a lot of other game playing happening. So directly to the question of how does this affect your individual vote, we talked about possible two-track election system where in theory you could get disenfranchised under one track and not under the other, or there's confusion about how all of this would work and where your vote would end up. And obviously what we've talked about earlier in terms of partisan gerrymandering and whether your vote would have the effect that you would want it to have, even if you can cast it. These are all the things at stake here and more.
Well, it does make us feel a little bit better, the clarification from Ethan and the professor about that. Anyone else want to pop in on anything that you want to say? Any other questions? We've been, oh, wait a minute. We got another one popping up here. Anonymous attendee. I think Professor is answering to you, including Clarence Thomas's wife. That was maybe more of a message. Oh, I see, Professor. You've put some, Federalist number 47.
Yes, I found what I was thinking of about Madison and tyranny.
Yeah.
The convenience of having my Google to my side here.
I know. I'm thinking you're really good at this, being a panelist, answering questions, listening, and then doing a little search also. That's really good. Sally, I knew you would have a question. I was wondering when it's going to have, because we're gonna wrap up before 3 o'clock. Our guests have been very generous with their time. So think about any more questions. And I have a few more too, because we want to get to the point of what now, what after this. Like December 7th, I was focusing on it so much. And then, to hear the case. Let's see. Sally says, now that we have a Supreme Court that favors states' rights and our final arbiter of appeal, wouldn't this affect the right to remedy? Any answer to that? Maybe not, Sally. Or you can explain a little bit more. What I wanted to kind of talk about and pull in Tyler and the Reverend and other folks too, because over this last year or so, Ethan, the exact time, and Professor too, and Billy with the work on the courts, you all have been very busy. And what can we advocates, activists, general public, people who are concerned about this, what can we do? What can we do as a group? What can we do on our own? And maybe you've thought about some of these things. So Derek, you can go ahead if you'd like.
Well, first thing I urge everyone to do is, take the time. If you're someone who prays, pray about it. Ask for guidance. If you believe that there's something guiding your life, ask for that guidance, because for major decisions in regards to this matters. For some reason in America, we have this idea that you don't talk about religion and politics, but in studying the Hebrew Bible and the New Testament, there's a heck of a lot of overlap there. And I think that we're called as people of faith to uplift those around us. And if someone is being treated unjustly or injustice is rampant, it's our role as people of faith to speak up and say, this is not what we're guided to.
And it.
Oh, wait a minute. I'm muted. Sorry about that. But thank you for that. A very good point. I'm going to get to Billy's question because it was quite the obvious question that I missed. But Tyler, what continues with Common Cause in North Carolina and the Harper? As I was investigating and researching a little bit, the Harper is Rebecca Harper, because oftentimes, and for folks who don't follow the courts and legal cases as much, we hear these names, they're names of the court because that's who are part of the litigation. And Harper is Rebecca Harper, correct?
Yes, she is one of our board members on the board for Common Cause NC, and so she's the named plaintiff. And it actually stems from the Harper v. Hall, which was the North Carolina case. But to get back to the question about what we're doing and what people can do. First, I think that just, what we're doing here, having this webinar, bringing about awareness is really important. It's important that people understand the implications of this and understand what's happening and why it's happening. But I think that moving forward, it's very important that you contact your legislators and ask them where they stand on this. Do they support, Moore v. Harper? Do they think that they should have this type of power? And, I think that they ought to be questioned about this before 2024, because they're going to be up for re-election. And also, question them about where they stand on voting rights issues. I'm really concerned, and the professor brought this up with the 2013 bill that was passed in North Carolina, a really bad voter bill that would have gotten rid of a big chunk of early voting here, gotten rid of out of precinct voting. It got rid of pre-registration for 16 and 17-year-olds and implemented a restrictive voter ID that where they actually researched what types of ID Black people used and tried to keep those off of the list that would have been accepted. So I'm concerned that we could see a state legislatures throughout the country that feel more emboldened to go back to that and implement that because, hey, state courts, we don't have to worry about them anymore. So I think it's really, really important that that your legislators, and no matter which way this case goes, that you have legislators at the state level that care about voting rights and don't support this case.
Yeah, that's really good. So I know that these activists and advocates who are on and listening will very much take that to heart. I mean, we've seen it over the last couple of years, especially with the Freedom to Vote Act and the work that was done here in West Virginia. And I showed this to a few people because, Tyler, you say be aware, and this might be this webinar and forum, I hope, alerts people not to be this always on edge. But I recently read an op-ed by our current Secretary of State, and transparency, he's the guy that I lost to for Secretary of State. But in this, he talks about the Constitution, Article 1, Section 4, that gives legislatures the responsibility for the time, place, and manner of holding elections. He goes on a little bit more and says, our founding fathers felt state legislatures, as opposed to governors, judges, attorneys general, and secretaries of state, were best suited to set the rules for holding elections. Thus, when a legislature writes election laws, it is incumbent on officials to strictly adhere to such laws. Now, you wouldn't think, immediately, well, yeah, he's exactly right about all that. But I've never heard it put that way before ISLT became really, so my concern is this is what you see and this is what you set up. And maybe it goes back to your point, Tyler, just plain out ask your lawmakers, your elected officials, where they're coming from and what they think about it too.
I also think that, oh no, go ahead, Tyler.
Oh, I was just going to say, quickly, I don't think that people are arguing that state legislatures shouldn't, be able to write election laws. But what we're saying is there has to be a check.
Yep.
There is no branch that should have this type of unchecked authority. So yes, state legislatures can write election laws, of course, but state courts have to be able to come in if state legislatures go overboard.
Yeah. Hey, Tyler, there's a question directly toward you and Common Cause from Natisha. She's with, it must be North Carolina APRI, located in North Carolina. What are some of the strategies to fight oppression going toward 2024? Do you have any events coming up with Common Cause, especially with our youth? She's getting down to specifics.
Yes. So at Common Cause NC, we actually have an HBCU program where we have HBCU fellows that are trained and work on their campuses to support voting rights issues and help bring about awareness on their campuses. So we do a lot of work on campuses year round with that. We actually are just coming off a big Morby Harper Map Our Future tour, where we went all throughout the state we hit most of the state's 100 counties to educate people about this. So we're many of us are tired from that, but we are going to continue pushing into next year to certainly hold more events and continue with those educational efforts. But we are definitely doing a lot in that regard, and we're very connected on all the state's HBCU campuses as well.
Okay, yeah, I mean those are important, and continue on with information like this. Sally, I did want to get one more thing. When you were talking about it's important to know who's running for the judiciary and to try and research their philosophy or method of constitutional interpretation. Yeah, I mean, I know it's when we ask questions of judicial candidates, they can always say, well, I can't say anything about this. So what do you say about that, Billy?
Well, my suggestion to people would be to do the research to find out about this candidate's record, right? If they've been a judge before, how have they ruled? If they're a lawyer, who have their clients been? And a lot of times you can find groups like the ACLU or Planned Parenthood that have evaluated the candidates' records. Because you're absolutely right, Natalie. I mean, when you ask judges about issues, they can't answer because it would violate the ethics rules. But you can gain a lot of information, I think, by looking at their records as lawyers or as judges, and relying on, your local media. A lot of times editorial boards will provide a lot of information about the candidates, and also different kinds of organizations will evaluate them as well.
Yeah, I mean, it's kind of, you answered that question from Betty Brevard. Can we get a short list of key questions to ask our legislators? Yeah, like, I mean, I guess we can see some of their record too, but
I think people should also think about there are a lot of things that Congress could do in addition to protecting voting rights and outlawing gerrymandering. There's a lot of things that they could do about the U.S. Supreme Court as well. They decide what kind of jurisdiction the U.S. Supreme Court has. They decide how many justices are on the U.S. Supreme Court. They can decide how many votes the U.S. Supreme Court needs to take a case. So there's all kinds of ways that Congress can act to rein in this U.S. Supreme Court, which is coming for so many of our rights. So I would encourage folks to talk to their members of Congress about that and their senators.
Yeah, I think we all, I can speak for myself. I learned more about how justices take cases based on this Moore versus Harper, that, they need 4, they had 3, and now we're going to be looking at Roberts,
Barrett.
Yeah, Barrett and Kavanaugh, all of those. And of course, Sally's getting in her point for check on who's funding abortions, or not abortions, campaigns. You can tell we're all right. Talking about here. All right, sure. The last question. So how did the panelists think the court's going to rule? Who do I let go for? I'm going to start with you again, Tyler. We'll just go all the way across the screen.
I think, I know we talked before about the amicus brief with the Chief Justices, which I think is remarkable. But I don't think it's really all that surprising when you think about it, because they are talking about upholding the power of the judiciary at the state level. And, I'm hopeful that the U.S. Supreme Court will recognize that we are arguing for the ability of the state courts to continue to provide a check and to have the ability to enforce their own rulings, basically. I mean, like I said, North Carolina, where they struck down partisan gerrymandering as illegal, if they don't have the ability to come in and allow special masters to draw a map if the legislature can't come up with a good map, then they don't have an ability to back up their ruling. So I'm hopeful that the court will see that and see the importance of the judiciary at the state level. But I don't know. I don't know. We'll have to see. They may implement some sort of middle ground where they recognize part of it but not all of it, and try to come to a middle ground there. But we'll see. I mean, hopefully they strike it all down, but
yeah,
we'll see.
That's what I'm pushing for. That's my Christmas wish. Pastor Biondi, what are you thinking?
Well, I honestly don't know which way it's going to go. This court continues to surprise me. What I do know is that people of faith will still have work to do, regardless of what the decision is, and that democracy is constantly being undermined because special interest has a lot of say in that matter. So we're going to continue doing the work we're doing, regardless of what is decided.
Yep, great points, and thanks for being a great partner in all of this too. Go ahead, Billy. What are your thoughts?
Well, it's really hard to say. I mean, I think it's clear that a few of the justices are going, well, really on both sides, on the left and the right. I don't know about John Roberts or Justice Barrett. I thought they both had really good questions for both sides. So I think that the court will probably try and sort of find a middle ground. I hate to sort of describe it that way because any ruling in favor of the legislature is a big change in terms of the Constitution and federalism. But I don't think that all the conservative justices are on board with the broadest possible interpretation of this independent state legislature theory. So I think we're going to get something maybe that says state courts can't strike down these districts based on these really vague provisions of the Constitution. I don't know. It seems like all nonsense to me, but that's kind of my guess. But definitely the work to defend democracy continues after this for sure.
I think we lost Natalie. I'm happy to.
I'm back. Hey, then you're going to take over for me. I appreciate that. I'm not sure if I can see everybody else. Can you see me now?
We can't see.
We can hear you.
Yeah.
Yeah.
Okay, I'm going to take my camera off, so I don't see you guys yet. Have you had the opportunity? Did the professor go or you go?
No, Ethan was going to go, I think.
Sure. Yeah, and then we can
go ahead.
Sure. So, as everyone else said, it's impossible to predict what exactly will happen, but I'll make 3 quick points. The first is that the North Carolina legislators arrived at the Supreme Court and they doubled down on their radical and ahistorical interpretation of the Constitution. And let's just be really clear, they're asking for permission from the Supreme Court to violate their own state constitution. Reassuringly, most of the justices didn't seem all that interested in that really extreme proposition. Justice Barrett seemed uncomfortable with the idea. Justice Kavanaugh seemed uncomfortable with the idea. At one point, he had called out the lawyers for the legislators for wanting to go even further than Bush versus Gore, which was an opinion that Justice Kavanaugh had worked on when he was a young lawyer at the Bush administration. So reassuringly, it seems like there's not a majority of the court that's willing to embrace it like that. And so there's reason to hope that the court will reject the more extreme forms of the independent state legislature theory. And as Billy said, any form of the theory that nullifies state constitutional provisions is extreme and would doom an intolerable amount of election law and an intolerable amount of protections of your right to vote. So we'll see. There's still a danger that the court could announce some rule that would handcuff state courts and make it harder for them to protect your right to vote. That would functionally, if not formally, nullify certain crucial state constitutional provisions. But the argument went better than it could have went yesterday.
Yeah. Professor, you can round us out.
Sure. I mean, I I think we have a lot of great points here. It is impossible to predict. I would think that if it gets adopted, it is not going to be an extremist form of this, as Billy and Ethan have pointed out. And I think, moreover, that the battle for our right to vote, the battle for our democracy continues. I take away from today that not only, well, A, the independent state legislature theory is nonsense, given our constitutional structure. B, that there is so many threads to our democracy and protecting our vote. And by pulling on this big thread, we're running the risk of seeing a lot of this fall apart. But C, the fundamental right to vote that lives in 49 of our 50 state constitutions and by legislative directive in the 50th, is still inviolable. There's not going to be a day when you can't go vote, but you should use that power. All of those suggestions about getting educated, being informed, learning who the judges are that you're voting for and the legislators that you're voting for, how they think, make use of that power and get more folks, including the young people out there, to make use of that vote. Even though these changes might be out of our hands, we can still control our state and local governments. And we need to make use of that power, and we need to spread that message as well.
Yeah, some very good points. A good place to end. I know Diane asked about expanding the court, but we'll use that for next time, because I think that another forum, another platform like this is always important. And I thank you all for coming on. We're talking a lot about this. Tyler's been all over the state of North Carolina, so a stop off in West Virginia, I appreciate. and thank you all. Thank you to the participants and to our audience and to the media who were on. I know I saw some reporters tuning in here too. So if you have any follow-up questions, you can follow us up here. Me personally, you can also go online to Race Matters on the Facebook page and listen to this again if you have more questions. So panelists, thank you all very much for being here. And thanks for those tuning in. And until next time when we're talking about ISLT, have a good day.